Good morning, all of you. Today, I will explain short introduction of intellectual property right, IPR, and patent registration process. IPR is a very important topic nowadays. Every year, about 2 and 3 questions comes in all competitive exams like UPSC, ISC, and other exams. So, all engineering students and technical study persons should know what is the IPR and how it is useful in everyday life and what is their importance. It is totally related to the ownership of the creator. It is totally related to the concept of the ownership of the creator like it's a property. It is a property, and property, property is the two types. Number one is the tangible property and another is the intangible properties. Tangible property are those property you are the owner of that property which can you see, which can you physically approach you, like physical objects like land, household, good, car. It's your tangible property. You are the owner of these property. But intangible property, these property you cannot see. You cannot watch them. You can only feel them. Then inventions, literary works, artistic work, designs, symbol, logos are all properties comes under the intangible property. So these intangible properties is also protected by the law, and if someone can misuse your tangible property, you can go to the police and you can complain that it is my object and another one is use it. So it is tangible properties, like tangible properties, all intangible properties comes under the IP, means intellectual property. It means creation of mind, and the right is given to the creator, owner, who create the invention. The owner have the right, he can claim their invention to anyone. But how he claim that it is the property is there? If he get registration, proper registration according to the IPR rule. So intellectual property is also right to the ownership. Okay, bachcho, clear? Now, you know what difference between the invention and the discovery? There is too much difference between the invention and discovery. Invention means new, something new can be invented. But discovery means already exist in nature, it will be discovered. Then discovery is not patentable. Clear? Discoveries is not patentable, but all invention is patentable. There is a difference between the invention versus innovation. Invention means creation of something new. Maybe it is new knowledge. But innovation, if innovation is transformed of resources into useful application like product, new process, then it will be innovation. Okay? There is a difference between the invention and innovation. Clear? Invention, if new knowledge, then it is not patentable. Means if you want to patent this product, then you can to change into product or process. Intellectual property right. Intellectual property right are the right given to a person over the creation of their mind. It is a creativity. It is the innovative idea of that person. So they can protect their ideas by the law. They easily give the creator an exclusive right over the use of his creation for a certain period of time. It is an exclusive right for the owner. He can sell, he can use it, he can transform it. Okay, but its time limit is the tenure is about 20 years. What is the intellectual property right? I I stand for creation of mind, ideas, created image like Eureka movement. Property, it is an intangible property that is created by mind. And right, it comes under with law. Okay, so intellectual means creation, something new. Then it comes under the IPR की full form है ये. IPR enforce mainly three IPRs are represented here: trademark, copyright, and patents. IP, intellectual property, is a property. I tell you, it can be sold, it can be bought, it can be leased or rent. Under the deed of the assignment, you can give your certain period of time, your process or product, to someone else who can manufacture your unit or who can use the market customization. Any other person can pass under a will, can be assigned also. So it is your property. How you can use it, it depends upon the owner party. The role of IP as a intangible property: economic right of creator. It's a property of the creator, so he has the right of economy, how he used as a commercial business and market purpose. Commercial exploitation of owner of IP. Capital expenditure, transfer of technology. Someone want to transfer their technology to other person, and then he can transfer that technology to other person. Culture development. So there are so many roles of IP as an intangible property. Why IP protection is given? IP protection is given because no one can steal your property. It's your innovation, it's your idea, and you have to protect your ideas, you have to protect your innovation by certain law. Okay? So IP, no one can misuse your innovation, no one can transfer your innovation to other person, no one can steal your innovation. So IP is protected. Capital expenditure for new product, R&D work, research and development, marketing and advertisement, no freeloaders, maintaining loyal followers, and profit. Mainly IPR is two types. First one is the industrial property right, and another one is the copyright. IPR is a two type: industrial property right and copyright. In the industrial property right, there is a four types: patent, trademarks, industrial design, and geographical indication. Industrial property is the four type: patent, trademark, industrial design, and geographical indication. And copyright is again musical work, literary work, and artistic work like broadcasting, dramatic work, sound recording, computer recording. These all comes under the copyright law. Okay, so there is two law: industrial property right law and copyright law. Patent, copyright, trademark, industrial design, trade secret, geographical indication, and patent, copyright, same thing. IPR, IPR is protected. R, R term for whenever registered trademark, and TM trademark, and C for copyright. Protection for copyright. Protection given by law for a term years to the composer, authors, etc. Work includes literally artistic, musical, film, sound recording, broadcasting, and cinematographic, commercial, and moral right. Copyright symbol is C. Trademark. A trademark is a type of intellectual property, consists of recognizable sign, design, expression, while identify product or service of a particular source from those of the others, so that the product and design will be different from the other. The trademark used to identify service are usually called service mark. The trademark's owner can be individual, business organization, or any legal entity. A trademark may be located on a practice, a label, a voucher, or on the product. It identity. Trademarks are often displayed on complete buildings also. You have seen that there is Google building, Amazon office, and Infosys office. The building name is also different letters created. Trademarks are often displayed on company buildings. It is legally recognized as a type of intellectual property. And trade secret. Trade secret, it is a secret. It's not open to the, it is your confidential document. You have to secret your formula of recipe, formula of any process. It does not disclose the with the other one. Like Coca-Cola, so Coca-Cola chemical formula is not disclosed, and food recipe of KFC comes under the trade secret, and some other manufactured techniques they comes under the trade secret. Like trademark, there are different types of trademarks. Shape, shape is different shape. Coca-Cola shape, different shape. Pepsi shape, different shape. Limca and other bottles are different shape. Even Bisleri water bottles are different shape. Then shape is also trademark symbol. And there is a name, writing of name pattern, symbol, symbol M, MACD symbol M, slogan I am love it, and they are writing text, orange color, logo type Volkswagen, Swift, Mahindra, Kotak Mahindra, Taco Bell, Kotak Mahindra, Tata, Bisleri, Humdard, Volvo, Yahoo, Bata, Q. They all are the text material. So trademark is the text, symbol, design. So many types of trademark are there. Next है GI, geographical indication. Next IP is the geographical indication. Mainly it depends upon the particular area. The product is mainly for particular area wise, and like basmati rice, Mysore silk, originated in Mysore, Mysore sandalwood oil, originated in Mysore sandalwood oil, Mysore sandal soap, Mysore jasmine, Kur orange, Madhubani painting, Darjeeling tea, Dharwad peta, Alfonso mango, Tirupati laddu, Kolhapuri chappal, Nanjaguru banana, Canadian whiskey, bird GIs, Swiss watches, Florida oranges, champagne, tequila. These are the word level GIs. So GIs means particular geographical area, particular ream, product of the particular ream. They may be natural or they may be man-made. Lizard papad, basmati rice, Darjeeling tea, Banarsi sari, and Bikaner bhujia. They all are comes under the GIs. Patent. Now, patent is the main topic. I will discuss here patent prosecution process, patent registration process, what is the patent, how we patent your ideas. Okay, so patent, you are the owner, it is your exclusive right under the law. You can give your contact application, it's your property, granted permission. Patents. Now discuss the patent. Patent is very important topic for all engineering students, even all BSc, MSc science students. A patent describes an invention, creation for which the inventor who create the ideas claims have their exclusive right. What are the patentable? The patentable criteria invention which is novel, absolutely new, and which have the useful nature and not obvious nature, pertains to patentable subject matter. Who can be applicant? The inventor, who have the creation, they have the ideas. Assignee of the inventor, natural person and legal entity can be patented. The legal representative of the diseased applicant. application. There are three applicants. Patents in India, Patent Office in India. It is administered by the Office of the Controller General of Patent Design and Trademarks CGPDTM. Okay, Patent Office in India. It is administered by the CGPDTM, Ministry of DIPP, and CGPDTM, Controller General of Patent Design and Trademarks. Subordinate office government in India. DIPP means Department of Industrial Policy and Promotion. There are two departments, DIPP and CGPTTM. Headquarters at Kolkata, Mumbai, Chennai and Delhi. There is the four patent office, Kolkata, Mumbai, Chennai and Delhi. Patent law in India history. First amendment, the Indian Design and Patent Act was enacted in 1911. The current act came into force in 1972. Patent amendment in 2005 and new rule patent amendment is in 2021 also. Patent registration process. Patent application at the local patent office, either online or offline. Both mode is applicable. You can approach by the offline mode and by the online mode also. The office will check the patentability conditions. There are so many steps, and after the completing the office procedure, the patent will be granted. There are main six processes for the patent prosecution in India. Different states, different country have their different patent prosecution. It is not applicable for worldwide. All states, means all countries, have their own patent prosecution rule, patent prosecution properties. ठीक है, तो patent is a territorial right. It means patent is a territorial right. It is comply only your country. It is applicable only per country, and patent is not a worldwide. Patent prosecution in India, first of all, filing the patent. Second, after filing the application, your application will be published in a gazette, Journal of the Patent magazine. After the publication, examination will prefer. After the examination report will done, and examination report, if there is no objections, then it will be free of the objection and respond to objections, and maybe it will be done by the hearing by the controller. After hearing, objection is sustained or overruled, both depends upon the hearing, and after that, grant of the patent. Documents required to file an application in India: a covering letter with identity proof of resident of India, a duly filled application form 1, 3 and 5, patent specification form 2, along with proper claim and fees. These some important documents are very essential and required for the filing of application in India. Filing of patent application. Before the filing of patent application, it should go for the prior art search. How this invention and how creation is this new? You have to know the idea that this is the new. You have new ideas in your mind. Your creation is, no one knows your creation. The invention is almost new. Then it is the prior art search. If there is already it present in the public domain, then it cannot be patentable. Clear? If it is already present in public domain, by the conference paper, by the journal paper, and by the other sources, then it cannot be patentable. Patentable is very new. Almost absolute new term is used for the patentable. And after the prior art search, filing of the patent application, patent office, either online mode or offline mode, both mode is applicable. with the requirement of these documents. After filing of the patent, publication of patent will be after 18 months. Patent registered patent application will published. After publication, RQ will done. RQ means examination of request to publication. Examination, grant or refusal. After examination, there will be hearing, pre-grant opposition and post-grant opposition. Long term, I will discuss in later on. And hearing, if there is any objection, then hearing of with the controller. Maybe objection is refused. If not refused, then not granted. If they are refused, then grant is publication of grant of patent. Post grant opposition is sometime also comes, and decision by controller, it will be granted or not granted. Important points for patents. Patents are territorial right. Territorial right means particular belongs to particular country. In general, it is an exclusive right only applicable in the country or region in which a patent has been filed and granted. It is very clear to all of you. It is a territorial right and it is an exclusive right. Correct? Exclusive right for a particular realm, for particular country. The product or process can be sold, can be marketed, customized only in particular realm. The protection is granted for a limited period, generally 20 years from the filing date of the application. Mainly 20 years, the term of the one term of patent is the 20 years. Tenure of the patent is the 20 years. The patent owner has the exclusive right to prevent or to stop other from commercially exploiting the patented invention. Patent protection means that the invention cannot be commercially made, used, disturbed, imported, or sold by others without the patent owner consent. Okay, clear? The patent owner has the exclusive right. I remember the first time I heard this word patent in the movie of Three Idiots. जब आमिर खान ने क्या नाम था उसका साइंटिस्ट बन गया था, उसका नाम था कुंफू बांगडू करके, तो उससे मिलने के लिए उसका एक फ्रेंड आया था, तो उसने पूछा था कि उसके पास तो उसके 3000 पेटेंट पब्लिश्ड है, इसलिए मैं उससे अपने साइंटिस्ट से मिलने आया हूँ. तो आई हर्ड द पेटेंट वर्ड एट दैट टाइम, फर्स्ट टाइम. देन at that time I was in BSc classes. So patent is no, so many people, so many students are not aware of this word patent. What is the patent? What is the IPR? It is very important topic to all of you. Now after this lecture, I think you have to clear the patent word, IPR word. The patent is the very important and exclusive right to the creator. It is the innovation. It is the innovation. It is the property of someone. No one can misuse their property. To prevent or stop from commercially exploiting the patented invention, it is very important. If someone can misuse or someone can cannot lead properly, they can claim, they can infringe, they can sue the file. Some inventions which are not patentable in India, anything obvious contrary to well established. Natural laws is not published. They are well established, like Newton's law, Einstein's law. Anything that is formulated or depend upon that principle cannot be published. They are not patentable in India. The mere discovery means two arrangement and rearrangement or known arrangement is not permitted, not patentable. Like bucket fitted with doors, yeah, umbrella with wear what, other invention related to atomic energy is also not patentable in India. So patent is very important for all purposes. Top patents in India. Top 10 patentees in India. Number 1, Qualcomm, USA company. CSIR, Indian company. Samsung, Indian. GM Global Technology, USA. Technokipolas, Sweden. Samsung Electronics. Samsung Indian Software Operation. Siemens Thermo Licensing, recent Hindustan Unilever. Patent leaders in world. IBM, Samsung, Google, Qualcomm, Canon. Cost and patient benefit. Like cost of Navaxia is bears 2.85 lakh. Patient 2% patient will recover. But this is patented by the NATCO. NATCO's cost is the 8900, free to needy person. So that is patent is also cost effective and patient benefited. This is the patent on turmeric in wound healing. It is patentable in US, but it is not patentable in India. In India, anything which is come under the TKDL. TKDL means होता है traditional knowledge digital library. There is a traditional knowledge digital library in India. There is the so many thousands of medicinal value of plants, herbs are mentioned there. So the in the TKDL, traditional knowledge digital library, there is so many books. There is a mention of the herbs, serves, and spices for healing purpose, for medical purposes. So that cannot be patentable in India, but in US it is patentable. Infringement means if there is already patent is exist in that particular area and some other person can also use that product after the after that one person that is already used and he can file the suit. He can file the suit and by the infringement. Then infringement cases also is there, like coronavirus patent, also patented. Patenting of neem, a case of biopiracy. Biopiracy is the means theft of genetic material, especially plants and other biological material by the patent process. Patent process it is comes under the biopiracy. Okay? Corporation of the Western world have since the past 2 decades or so been reaping immense profit by patenting the knowledge and genetic resources of third world communities. It also form under biodiversity hotspot. They comes under the biopiracy. Once patented, the patent owner can effectively prevent competitors from producing the product, occasionally even interfering with the lifestyle of the community, which is the original source of the patented information. In such case, farmers and community and livelihoods are also threatened. This is the Indian Patent Office. WIPO is the World Intellectual Property Organization established in 1967 and Indian Patent Act is established in 1971. Clear? The WIPO is a specialized agency of the United Nations. It promotes the protection of IP throughout the world. Its headquarters are in Geneva, Switzerland. So, as IPO, Indian Patent Office, and WIPO means World Intellectual Property Organization. Okay, the main mission of the WIPO is the World Intellectual Property of Organization promotes innovation and creativity for the economic, social, and cultural development of all countries through a balanced and effective international intellectual property system. This is the mission. Some important sites for patent information: IP India, USPTO, Free Patent Online, Patents Stone, Wikipedia, WIPO. If you have any innovative ideas, any creation, then you should first file your application. Your application date is the priority date of filing of your application. If someone also file this application, then who file first, give the priority that person. Maybe you become late person. So it is depend upon the date of the filing. The judgment of the priority date is depend upon the date of filing. Like आपने वो क्रिएशन किया, आपसे पहले हो सकता है किसी और ने भी वो क्रिएट किया और उसने सोचा हम क्रिएशन जो मैंने इन्वेंशन की है उसका मैं पहले कुछ कॉमर्शियली यूज कर लूँ, उसको मैन्युफैक्चरिंग करके मार्केट में सप्लाई कर देती हूँ, बिजनेस आ जाता है, फिर मैं फाइल करना शुरू करता हूँ। इस तरह उसने सोचा तो उसके इन्वेंशन को उसने एक प्रोडक्ट बनाया और उसको प्रोडक्ट को लोकल मार्केट में सप्लाई करना भी शुरू कर दिया और उसने अर्निंग भी शुरू कर दी, बट ही फॉरगेट टू फाइल द एप्लीकेशन। सेम उसी प्रोडक्ट को किसी और ने फाइल कर दिया, किसी और ने उस एप्लीकेशन को फाइल कर दिया, आफ्टर फाइलिंग उसको पेटेंट के पब्लिकेशन हो गया, पब्लिकेशन का ग्रांट मिल गया। अब उसके पास ये राइट हो गया कि वो फाइलिंग वाला पर्सन, जो पर्सन ऑलरेडी मार्केट में पहले से है, उसको वो इन्फ्लुएंस कर रहा है, उसके लिए सूट कर रहा है कि ये मेरा प्रोडक्ट बेच रहा है, जबकि वो प्रोडक्ट उसका नहीं है, ना प्रोसेस उसकी है, लेकिन उसने अपने प्रोडक्ट और प्रोसेस को पहले से क्या नहीं किया, प्रिवेंट नहीं किया, उसने अपनी राइट नहीं ली, देन हाउ ही कैन क्लेम दैट इट्स देयर प्रोडक्ट। ठीक है, तो हमें प्रॉपर अपनी इन्वेंशन को राइट लेने के लिए उस एप्लीकेशन को फर्स्ट यू हैव टू फाइल योर आइडियाज। तो हमें उस आइडिया को फर्स्ट फाइलिंग करनी है। अगर आप फाइलिंग नहीं करेंगे, आप सोचेंगे मुझसे थोड़ा अर्निंग कर ले, कुछ कमर्शियल बेनिफिट हो जाए, या हम सोचते रहे हाँ उसको फर्दर और करेंगे और करेंगे, फिर मार्केट में बहुत लोग हैं इस काम को करने के लिए। और वैसे भी कोई भी इन्वेंशन होती है तो इन्वेंशन मेनली क्रिएट कब होती है, कोई प्रॉब्लम का सॉल्यूशन के लिए। अगर कोई प्रॉब्लम है उसको सॉल्यूशन होना है तो इट मींस इन्वेंशन है। जितने आजकल स्टार्टअप्स खुले हैं वो सभी क्या है, इन्वेंशन फॉर्म में ही है। स्टार्टअप सभी क्या इनोवेटिव आइडियाज है, तो वो सब पेटेंटेबली अप्रोच करते हैं, लेकिन फर्स्ट कम फर्स्ट सर्व वाली फीलिंग से नहीं, जितना जल्दी आप एप्लीकेशन फाइल करेंगे वही आपकी फाइलिंग डेट होगी, वही आपकी प्रायोरिटी डेट होगी, जिससे कि कोई मार्केट में आपको डिफीट ना कर सके। ठीक है, तो as you have to creation your mind, you have your ideas of any problem, any solution, then you have to file your application. After filing there is too much long process, publication, examination report, hearing, pre-grant, post-grant, opposition, after that grant of the patent. After patent will be granted, you have to protect your ideas. Now it's your choice, you have to sell your ideas, you have to release your ideas, you are now exclusive owner of your right, and now you are depends upon you how you can use it. Then it is very important to protect your ideas by the IPR law. It is very important for a successful business. Thank you. If you have any query, any doubt, please ask me, and the comment section you can ask, and you can query, write your queries, any doubt, any queries. So it is very important to all of you that patent prosecution depend upon your concept of the ownership. It depends upon the concept of the ownership. So whenever you have any idea, it is very new, novel, and useful application, then you have to file that application in a particular manner, because it depends upon the priority date. Those who have filed first, they have to approach for a granting patent. Okay, thank you bachcho, good luck, take care. Please post queries in the comment box. I will try to reply your all queries related to IPR, copyright, trademark, trade secret, geographical indication, patent prosecution, specification, and any other. Please write in comment box. Thank you, bachcho. Good luck. Take care.